to attend. Aretha wants to walk us through a couple of comments at the beginning, and then I will welcome John Mascarin, and we will hopefully have the slides working. Aretha?
Good afternoon, everyone. I apologize for all the technology issues this afternoon. Hopefully the rest of the afternoon goes a little bit smoother. I'm just going to provide a very shortened protocol for electronic participation in this committee workshop. The purpose of the workshop is to discuss the open meeting exceptions under the Municipal Act. We will hear from John Mascarin, a certified specialist in municipal law. The recommended view is focus view or stage view, and this will ensure that you have a full view of the presentation slides. Pursuant to our procedure bylaw, no decision shall be made at this workshop. Any matter requiring a decision shall be reported to council or committee for consideration, debate, and approval at a subsequent meeting of council or committee. As quorum is not required for this meeting, we will not be taking roll call. If you'd like to request to speak, please select the raise your hand option on the WebEx platform. Thank you, and I'll now turn things over to the Policies and Procedures Committee Chair, Councillor Parrish. Thank you.
Thank you very much, Ms. Adams. I'd like to introduce John Mascarin, who's our speaker today and our guru on in-camera issues. He is a partner in Aird & Bearless. He is a certified specialist in municipal law, local government and land use planning and development, longstanding adjunct professor at Osgoode Hall Law School, teaching both, and I didn't know what these were, the JD and the LLM programs. JD is undergrad, which could have been said more easily, and the LLM is Master of Laws. So he teaches both levels of law school. He's the author of 5 leading texts in municipal and planning law. He's an integrity commissioner. He's a closed meeting investigator. He's an ombudsman for over 50 municipalities. And it's a great honor to have you here. I've been watching you on TV, commenting on the Toronto case, and it's been quite interesting. So I'm going to give it to you to take away.
Thank you very much, Councillor Parrish, and good afternoon, members of committee. It's my pleasure to be here, and I have been having some fun with what's been happening at the Supreme Court of Canada. I keep telling everyone it's going to be about 5 months at least before you get a decision there, and quite honestly, I think it's going to potentially have some bearing on provincial municipal relations for years to come. That's even if the province of Ontario ends up winning the decision overall. I still think that the City of Toronto has made some inroads. I mean, it was a 3-2 split decision at the Ontario Court of Appeal. But enough about that. I'm here to talk to you about open and closed meetings today. I think you should have the slide on your screen now. Is it possible that we could get it on a full view?
Yes, everybody just presses the little dot in the upper right corner and they get the full screen.
I'm trying to get it myself as well. Because I won't be able to otherwise see it unless it's on my my screen there. So, next slide. There you go. That's how I think people often feel when they come to a council meeting and all of a sudden they think they're going to see something and then they don't. It's the big thing on the door that says we're closed now. So I want to talk a little bit about the history. Next slide, please. So. This is a quote from a very well-known decision, Brantford and Montour, and it basically encapsulates the open meeting rule and what other decisions have said, including the very famous case that went all the way to the Supreme Court of Canada, RSJ Holdings and the City of London. The open meeting rule is there for 2 main purposes, and the 2 main purposes are to increase public confidence in local government, and secondly, to prevent secrecy in municipal decision making. Next slide, please. So here's the outline of what I propose to take you to. And by the way, my presentation is rather lengthy today, and there are some sections of it that I'll bypass and indicate to you that I'll just leave you with the slides in order to give you some background to it. But I won't take you through every individual slide because it'll be awfully long. But I want to talk about the open meeting rule, what constitutes a meeting, because that's recently changed through the Bill 68 amendments. Then I'm going to spend some really detailed time talking to you about the exceptions in the Act. There's currently, I think, 14 separate exceptions, and I'll talk about each one individually. We'll talk a little bit about electronic meetings, and we've had some flip-flop recently. As you know, there was limited electronic participation in meetings that the province had put in several years ago. And then because of the COVID pandemic and the inability for councils to actually meet during a lockdown, there were changes made to allow councils to meet virtually, just like we are today. And that was only during the initial state of emergency. And now, of course, it's been put in through another amendment to the Municipal Act. We'll talk a little bit about procedural requirements for going into closed session, what is required in order to do so. I'll speak about voting because there's very limited ability to vote, but there is the ability to vote in a closed session. Record keeping, something that's important. Just this morning, I had a council member write to me saying, I don't understand. My municipality is breaching the Municipal Act because they don't audio record their meetings, including the closed meetings. And of course, he's mistaken. They don't have to be recorded. There has to be a record kept, and I'll speak about that. And then I'll talk to you about closed meeting investigations. And by the way, full disclosure, you have delegated your authority to or appointed a closed meeting investigator to the local advisory services, which is a branch of AMO, and they have in turn delegated it to my firm. So I am the closed meeting investigator for the region of Peel, as well as I think about another 140 municipalities. I want to talk a little bit about electronic transmissions and how those could possibly lead to being an improper closed meeting. Reporting out, always an issue with municipalities, something that's not legislated, and I'll speak to that. And then finally, I'll end off with some common problems that you find always with closed meetings, and then some best practices that I would recommend, as well as the Ontario Ombudsman. So that's my outline for today. Madam Chair, I did not ask you, and I apologize. I should have asked you, because we're doing this virtually, would you like me to just go through the presentation and take questions at the end, or would you prefer that I take questions throughout?
Actually, to keep your continuity, I think we let you go forward, and hopefully all the counselors who are paying are here with us can put their questions on a piece of note paper, and then we'll take them all at the end if that suits you.
That's terrific, and I thank you very much for that. That would be my preference as well. It's sort of hard to see people on the screen, and sometimes I don't know if someone's putting up their hand, or you might not be able to tell right away with all the people on the screen. So, the next slide, please. So here's the open meeting rule. Ontario's governed by the so-called open meeting rule. All municipal councils, local boards, and committees of council must meet in an open public forum, and that's set out clearly in 239 sub 1. And if you look at it, it's quite simple, but there's an inherent exception right in it. It says, except as provided in this section, all meetings shall be open to the public. So there's an inherent built-in exception to it right away, and I just wanted to point that out. Next slide, please. So the open meeting rule has been in place for many years. In fact, it's almost 100 years old. The Consolidated Municipal Act of 1922 first legislated the fact that councils had to have open meetings. Before that, there was no requirement. And in fact, the press that old antiquated word, right? We talk about media now. The newspapers had actually brought a couple of court cases, and the court said, you know what? The requirement for meetings is statutory. So the only way that you can have an open meeting requirement is statutory, and there is none. So councils can meet in a closed session if they deem it appropriate. Sort of goes against the process today. Well, it was put in place in the 1922 Consolidated Municipal Act, and then it was significantly revised in 1994 through amendments made, because what was happening prior to 1994 is meetings were generally being closed based on the type of meeting rather than on the subject matter. So what council would do is they'd say, we'd have open, council has open meetings, but this committee is now meeting, and the committee would meet in closed session and really discuss all of the business of what should have been in an open session. So that was all changed in 1994, which imported in a new provision, Section 55, into the Municipal Act. And the current version is pretty much based on Section 55 of the old Municipal Act prior to the 2001 version, with, of course, enhancements made by the Bill 68 amendments back 3 years ago. And I'll speak to those in some detail in just a moment. Next slide, please. So I quote from the very famous case, the City of London and RSJ Holdings, that went all the way to the Supreme Court of Canada. For those of you who don't know the case, it dealt with an interim control bylaw in the City of London, where council went into an in-camera meeting and basically talked about possibly putting in an interim control bylaw to regulate student housing around Western University. And council really had the debate in camera, came out of the closed session, and in the span of about 8 minutes passed 32 bylaws, including the interim control bylaw, with no discussion whatsoever. The matter was challenged, saying this offends the open meeting rule, and there was an ingenious argument put forward by the City of London. They argued, well, Section 38, the interim control bylaw, doesn't require any notice whatsoever to anybody prior to it being enacted, not even to the owner. And it has a significant effect by freezing the ability of someone to possibly use their lands for development purposes for up to 1 year, or even longer if it's extended. And that was the case that was put forward. And the City of London and the Supreme Court of Canada said, well, we understand what you're saying about interim control bylaw. That doesn't mean that the debate and discussion doesn't have to occur in an open public session. It's important for the electorate, for the residents of that municipality, to see democracy in action. So that's essentially why I've quoted that here. It talks about the increased transparency and accountability, and the fact that if things are done in a closed meeting way, that it might undermine the democratic legitimacy of the decisions. Now, I've often said, as a closed meeting investigator, there's nothing wrong with going into a closed session if it's for a proper purpose and you stay to that purpose and you discuss the matter in which you are allowed to go into a closed session. There's nothing whatsoever wrong with that. And I'll give you a couple of examples about that as we go on. Next slide, please. So what constitutes the meetings? As you know, in Ontario, the municipal government must conduct the primary business that it does in an open session. And it's supposed to be at a meeting. So the definition of meeting was recently changed by the Bill 68 amendments, and this came into place on January the 1st, 2018. Meeting used to mean exactly what's just underlined in the slide. It used to just say, meeting means any regular, special, or other meeting of a council or a local board or of a committee of either of them. Now, many people have pointed out, that's pretty circular, and and it's terrible drafting. I mean, where do you define a specific term by using that same term in the definition? It's really awkward. The province decided to expand the meaning of meeting because there was some debate about what it would do. Now, I've indicated to you that I am a closed meeting, or my firm is a closed meeting investigator for a number of municipalities. The default closed meeting investigator as of January the 1st, 2008, was the Ontario Ombudsman. For the first time, the Ontario Ombudsman was given oversight into municipal matters, and that was to look at closed meetings. And unfortunately, in my view, the Ontario Ombudsman took this position where it countered and actually militated against the established case law here in Ontario. And Andre Morin, who was the Ontario Ombudsman at the time, used his own working definition of what a meeting is. And he indicated that it is any gathering of members, not a quorum, but any gathering of members that lay the groundwork for council business or decision making. So here is what the pre-Bill 68 jurisprudence used to say, and there's this famous case, Southern Inc. and the city of Ottawa. There's another corresponding decision. I'm quoting from the Ontario Divisional Court, but there's a similar case, also Southern Inc., but from the regional municipality of Hamilton Wentworth, that went all the way to the Court of Appeal, and it basically says there's a three-part test to whether you have a meeting. Whether the council members or a majority of them were invited, whether explicitly or implicitly, to attend a gathering, whether the matters that they discussed would ordinarily form the business of the council's decision-making process, and third, which I think is probably the most important of the three, whether those matters dealt with in such a way as to move those things materially along the overall spectrum towards an ultimate decision. That's what the Supreme Court, the Ontario Divisional Court and the Ontario Court of Appeal had said. Now, the Ontario Ombudsman took this opposite view, and I've put up this cartoon, which is actually the front page of what the Ontario Ombudsman called the most comprehensive, the most detailed, the most expensive closed meeting investigation that he had ever done, which was in the city of London. And he called it In the Back Room. As you can see, I think it's actually a caricature of Andre Morin in a Mickey Spillane sort of trench coat, from the 1950s. And anyone who gets that reference, we've just dated ourselves, right? So here it was in the back room.
John?
Yeah.
Can staff move to the next slide? We don't have the card.
My apologies. Next slide, please. Yes. There you go. I'm sorry. I moved ahead and I didn't let you do that. So here it is. Here's the slide. And let's move to the next slide. Here is what Mr. Morin said in that, and it was curious because he said, after a review of the relevant case law, it's beyond me which case law he was reviewing, and the principles of openness, transparency, and accountability, I formulated a working definition. And he comes up with this working definition that says, well, if you lay the groundwork, well, here's the kicker. I represented the mayor of London and 6 members of London City Council in this case. And my view is that they didn't do anything wrong. And in fact, Mr. Morin did the wrong thing by, as an investigator, changing the rules of what the law actually was. That's not what an investigator is supposed to do. An investigator is supposed to take the rules of the day and work with them. And what he did is he accepted our submissions and he actually appended them. This is rather extraordinary. He accepted our submissions, and I quote from it in Appendix A of In the Back Room. We indicated, it is our position that your adopted definition is overly broad and not at all supported by the established law. If accepted, the working definition would impose an unworkable standard whereby the mere mention of anything to do with a council or committee matter would potentially fall within the ambit of, quote, doing the groundwork necessary. And we indicate such a standard is unwarranted and, in our view, unnecessary. Next slide, please. Well, what's really great is that the province did bring in the changes to the Municipal Act, and as you saw in the slide just before, it does adopt. I think what we were arguing in the case that the established standard is, it has to be a quorum of council or committee that's present, and it has to materially move forward the decision making of council. Something that is purely informational won't offend the open meeting rule, but any discussion that seems to move forward the matter, the business of council, is problematic. So the next slide here, the one that we're looking at, electronic meetings, I've sort of given you a preface to. As you know, there used to be just an electronic participation requirement, which wasn't really electronic meetings. It basically said, as long as you have a quorum of members physically present at a meeting place, then there would be some members who could participate electronically, but they couldn't be counted to quorum. Well, this didn't really work when COVID-19 hit, and so therefore the Municipal Emergency Act 2020 put in place, seemingly for a limited period of time, the ability for council to meet local boards and committees to meet in a virtual or electronic setting. And I think to the surprise of a number of people, it actually hasn't worked too badly. I would actually argue that it's increased the ability of the populace, to the electorate, to be able to see what's happening at council. All they need is a click of a computer and internet access to be able to get to a council meeting. I know that there's this tension, and you can't ever replace entirely the ability and the engagement that you have in a face-to-face meeting. But just think of some of the difficulties that some members of the public may have in order to attend an open meeting of council that may be in the evening after they've come home from work, when they have kids to take care of, or youngsters to take to hockey practice, soccer practice, baseball. Aged folks, how easy is it for them to get to meetings, to get transportation, to be able to sit comfortably, in a setting that's public, to be able to use bathrooms? I think, quite honestly, electronic virtual meetings has made it more effective for persons to be able to see what's happening. And so now the COVID Economic Recovery Act that was recently passed back in August, September of last year, has indicated that municipalities, if they would like, can make further amendments to their procedural bylaws to allow electronic meetings to continue into the future. That means that you don't now have to have a physical gathering of a quorum of members. You can have the members all available in a virtual setting and be able to participate and vote in a meeting of council, committee, or a local board. Next slide, please. So here's where we're going to get into the meat of the today's session: closed meetings. As I indicated, the open meeting rule contains an inherent exception to it. It says, except as provided in this act. And so the act itself, the Municipal Act 2001, recognizes that there are limited exceptions to the open meeting rule, depending upon the subject matter that's being considered. There are 14 specific exemptions that apply, depending on the subject matter that's being considered. They are set out in most of them. I think 11 of them are set out in 239 sub 2. There are 2 additional ones in sub 3 and 1 additional one, I think, in 3.1, and I'll speak about them all. what you should know, and I think this is a misunderstanding many times, is that the exceptions for the main ones, the 11. I think there's 11 of them in 239 sub 2 and in the one in 239 3.1, they're all discretionary. And that's something that it is council or committee or the local board that decides whether you want to go into a closed session to discuss those matters. In some instances, just because you are speaking about a matter that may relate to, I'll just pick one, the property, the security of the property of a municipality, does not mean that you are bound to have to go in camera to consider that matter. There may be very good reasons why you do, but you're not bound to have to go. So those are discretionary. So that's my first comment, because that's a real misunderstanding, and I'll speak a little bit about later about who exercises the discretion. In general and overall, the exceptions have been applied narrowly and restrictively, on the basis that the general rule is all of the business of council should be in an open public forum. And so therefore, both the courts as well as the Information and Privacy Commissioner of Ontario have made determinations that in general, the exceptions should be dealt with on a restrictive and narrow basis. Next slide, please. So here I'll just outline very quickly, and then I'll go into each one. Here are the exceptions under 239 sub 2, and I'll just go through them quickly because I will go through each one. So here are some. Next slide. Here are some continuations. Next slide, please. Here are 4 new ones, and I want to highlight these before I get to them. So the original ones were primarily the ones that had been put in place. The ones all the way up to G, clause G, were the ones that were put in place in Section 55 of the Municipal Act back in 1994. Bill 68 made some amendments, and it added 4 new exceptions, and they're set out here. And what I've done is, because each one of them has a counterpart to to an exception from disclosure under MFIPA. So what the province sought to do here is align the two, because there was a misalignment before. You couldn't do some things that were in a closed session that were otherwise possibly protected from disclosure under MFIPA, and it just didn't make any sense. And I'll show you one example coming forward. So here are the 4 new ones. Clause H, information that is explicitly supplied in confidence to the municipality by the government, by the Parliament, or by a province or territory, or a Crown agency of any of them. Of course, the information has to be explicitly supplied. So there's an express conveyance of the information as confidential. That aligns to the non-disclosure exemption in Section 9 of the Municipal Freedom of Information and Protection of Privacy Act. The next one, I, is the third-party information protection. And this says that a person that may be doing business with a municipality may want to protect certain proprietary information. And it can be protected under MFIPA, but it was really odd that it could be protected under MFIPA, but yet if it came to council didn't have an ability to go in camera. And I'll give you one example from my world. I do a lot of work for municipalities. In fact, my clients are primarily 90% municipalities. And often municipalities will seek legal services through a public procurement process. And what we're asked to do is make an application, submit a proposal under a request for proposal, for instance, and this allows us, whoever's submitting, whether it's a consultant, whether it's a law firm, any other consultant, engineering firm, a planning firm, accountants, to say, I'm providing you with this information because it's necessary for you to make your decision. But I do want to protect some information. I don't want all of my competitors to put in an FOI request and be able to find out what my rates are, what I bid for this, or any discounts that I offered. And that information is allowed to be protected. And yet, council couldn't go into a closed meeting before to be able to consider that. So I think this again aligns with the provision in MFIPA, which is Section 10, which allows that information to possibly be protected. Now, there's an onus on the entity, for instance, me, if I'm submitting a proposal, to have to prove that there's a significant prejudice to my competitive position in the marketplace. So, I mean, there are these things. So H and I are new provisions. And next slide, please. There are two more, and J and K also have counterparts in MFIPA. J is the corollary to the third-party information. It says that any of that proprietary information that belongs to the municipality and that might be prejudicial to the municipality, if it were to release that information, can be protected. So you do have that ability now to go in camera to do that. And finally, the last exception, K, aligns with Clause 11E of MFIPA, where it says if council or committee is considering a position plan, procedure, criteria, instruction that it will be applying in any negotiations that are carried out, then you are allowed to discuss it in an in-camera setting. And before the Bill 68 amendments, you could not do that. So it was a real disincentive to municipalities. There were workarounds, and believe me, they were administratively cumbersome. There were some workarounds, and some municipalities were navigating it within the confines of the law, but it just made things much more difficult. Once again, let me say all of the exceptions that I've just talked about in sub 2 are all discretionary. My view, they're discretionary at the instance of council or the committee or the local board, the entity that's having the meeting. Often what will happen is, of course, the clerk, sometimes together with the head of council or the chair of the committee, will, of course, look at an agenda and will suggest that some things may be closed meeting items. But it's ultimately the decision and it's at the discretion of the entity that's meeting. So it's council's decision to make whether it will go in camera to consider any of the matters that we've just talked about. And it has to do so in a certain way. And I'll get to that just a moment. Next slide, please. I'm going to go through all of the exceptions now, and I'll give you a little bit of information with respect to each of them. The first one is Clause A, which is the security of the property of the municipality. Security is not defined, but the cases that have considered this exception have basically said security means the protection of the property. And the exception applies to discussions that seek to protect municipally owned property from loss, theft, damage, injury, and also the protection of public safety in relation to those things. The word property there is not to be confused with real property. It doesn't deal with just, a piece of land. And I think this was confused because, oddly enough, the Information and Privacy Commissioner in a number of early decisions discussing this particular matter seemed to take the position that property meant real property. And that was fundamentally wrong. It's property writ large. And the reason I say that is by pure statutory interpretation. The word property is not defined in this section of the Act. And if you look at the Municipal Act, when the Municipal Act means to say real property, it uses the words real property. It doesn't just say property. So clearly, this meant to be much more. The so it to and it also includes, by the way, both corporeal as well as incorporeal property. And if you don't know those terms, incorporeal property means something that's inchoate. Um, so, for instance, the official marks of the municipality, any intellectual property that the municipality owns. I actually once did an investigation where there was an allegation that a mayor had breached the code of conduct by wearing the chain of office in election campaign literature. And there was a preclusion in the code of conduct from using municipal property in campaign photographs and other materials. And so, in fact, I said, you have contravened the act. And she said, I just never believed that that was actually property. And I said, yes, that is, including things that are like intellectual property, trademarks, official marks, things like that, like the logos of the municipality. You have to be very careful if you're doing your campaign literature. You members who are sitting members of council, be careful that you don't have the logo there, because it sort of imbues it with your office and could improperly influence, and that would possibly be using the marks of the municipality for election purposes and might run you afoul. So there are some freebie advice from the integrity commissioner end. Um, the exception does not apply to discussions about financial or sensitive commercial information related to the property or to the general matters of health and safety. Okay. Next slide, please. The next one is personal matters regarding an identifiable individual. The purpose of this exception is to protect individual privacy, and it applies to information that if it is publicly disclosed, could give rise to a reasonable expectation that the person could be identified, and that's why it's there. The other thing that you should notice is it talks about personal matters, not personnel matters. Many people confuse that. They think, oh, personnel, it must mean, being an employee. It doesn't. It's personal matters. So that's really important. And it doesn't say personal information, which is, of course, something that is specifically defined under MFIPA. And I've given the opinion that personal privacy, personal matters, seems to me to be much broader than something that's a defined term and has a scoped, precise meaning. So it means something more. And the decisions of the Information and Privacy Commissioner have said that a matter becomes a personal matter to someone if there's any kind of allegation of wrongdoing. So I'll give you an example. Several years ago, I was asked to investigate a matter. I was asked to investigate it just as a lawyer. I wasn't an integrity commissioner. I wasn't an auditor general. I wasn't an ombudsman. The allegation was that a member of two councils, the mayor of the local tier and the regional councillor of the upper tier, had done some funny business with expense claims. The mayor of the municipality, who also by virtue of being the mayor sat on the upper tier, was entitled to attend conferences at both municipalities. So he attended the Roma conference and the AMO conference, one in the winter, one in the summer. And what he did is he expensed them both fully to both municipalities. Clearly wrong. I was asked to investigate, and clearly I found that the policies could just not be read. The expense policies of the municipality could just not be read to authorize him to fully get reimbursement from the upper tier and fully get reimbursement from the lower tier for the same conference. That would be double dipping. But in fact, the evidence appeared to indicate that that's exactly what he did. Anyway, I did an investigation. It came out that my finding was that he actually did this. The finding was very clear, and actually the mayor admitted that that's what he had done. And the question then became, is this personal information? And in fact, it was. I gave an opinion to both levels of the municipality, both the lower and the upper tier, that in fact, the report and my findings allege some wrongdoing on the part of the mayor and the regional councillor, and therefore that meant that that was personal information. And so the municipality said to me, "You mean we cannot release this?" And I said, "Well, technically, no, except for Section 16 of MFIPA has a compelling public interest." So, again, my opinion was there's a public figure probably doing something wrong with public monies. You've got me coming in being paid from the public purse to do an investigation. How can that information not be compelling and be something that should be out in the public eye? So it was released, and unfortunately, the story goes a little. It gets even worse. The council did not like this and basically asked me, "Is there any criminality involved in this?" And I said, "I'm not a criminal lawyer, but there are municipal corruption and fraud provisions in the criminal code." And in fact, the municipality decided to report it to the police services, and the mayor was actually found guilty of fraud and was convicted on that. Um, so anyway, a little bit about personal matters about an identifiable individual. This is the one, again, it's discretionary, but just think about it. Is it you want to have something like this? Again, not dealing with any particular municipality, but you have sexual harassment claims against potentially your senior administrative person, your CAO, your city manager. Some of that you just don't want to have in an open public forum, right? There may be compelling reasons why you should discuss some of this in camera. So that's just one example, and I know I've probably taken a very heightened and probably maybe even an offensive kind of example. It has happened, and I think initially that should probably, the initial discussion should be dealt with in a closed session, and then council has a discretion on how it reports that out. Next slide, please. Oh, here's some exceptions. I won't go through these. I'll just leave them for you. I've indicated that to Aretha and the clerk's department that you are entitled, of course, to have the PowerPoint slides, and there are some additional things that I won't speak about today in the interest of time. Next slide, please. And I think next slide. So here we are. Again, I talked about personal information and how that is different than what I think personal matters are. In my view, personal information has a defined, scoped meaning, and I think it's much more narrow than what the province intended under sub B, clause B of the Municipal Act. My view, personal matters is a bit broader. Next slide, please. Acquisition and disposition of land. The purpose, and this is very, very important if you're talking about this, the purpose of this exception is to protect the municipality's bargaining power. That's the underlying purpose. The municipality must be either the prospective buyer or the vendor of the property, of the land. Land, of course, applies to more than just the fee simple, and could include interest in land, like easements, leases, and things like that. So land is writ large here. It has to be a proposed or pending acquisition or disposition of land, not just a potential or speculative. So let me give you the example. The municipality wants to purchase lands to put up a community center. And if it goes out and starts saying that, the price may be driven up. So you might want to make decisions in camera and give instructions to staff to take certain acts without everyone knowing that you're going to be looking for a parcel of land located roughly in this area of a certain size, because that might drive the price up, and that would be against the public interest. Now, that's all fine if you've got some solidified purpose to doing that action. But if you're just thinking ahead, like in 15 years, might we need to acquire land? That, to me, sounds too much like potential or speculative, not an actual pending or prospective sale or purchase transaction. And that's the difference. The exception does not apply if there is no bargaining position to protect, again, such as when a transaction is purely speculative, or if the other party is actually in the closed meeting. Right. And I'll say this a little bit later because I often get asked the question. I'll just maybe preface it now. Who can attend a closed meeting? Well, clearly all the members of council can, unless there's a member that's declared a pecuniary interest. And then the MCIA requires you to step aside and not attend the meeting. But you might need to have certain staff there, maybe not all the staff that you normally have in an open meeting, maybe the people that you need to really speak to on that matter, depending on what it is. You may need to have consultants in, you may need to have, your legal counsel there. And there's nothing wrong with having somebody else. So you could possibly theoretically have someone else in the meeting, but the purpose here would be lost if you're actually going to have the vendor in the actual room or the purchaser in the room, because then you're not protecting your bargaining position, so therefore you lose it. So I wanted to make that that point dealing with the acquisition or disposition of lands. Again, it has to be a real pending acquisition or disposition, not something that may happen sometime in the future. That's, again, in my words, speculative. And I'll use that word again in just a moment. Next slide, please. Labor relations or employee negotiations. I'll leave it to you. Labor relations been quite broadly defined, and I gave you a case from the Ontario Court of Appeal. It does apply to matters dealing with collective bargaining agreements, including grievances, job candidate qualifications, terms of employment, job offers, things like compensation and vacation of specific employees, and of course, the very sensitive matters of the termination of an employment arrangement and any disciplinary proceedings. So all of those things would fall within the labor relations or employee negotiations. Next slide, please. Litigation or potential litigation. Now, I had this question put to me. I was doing a number of orientations for councils last time, and I talked just very generally about some of the exceptions. And there was a member of council, one council, who said to me, "Well, hold on. Anytime the municipality does anything, someone could sue us." And I said, "Well, that's not what this actually means. Litigation or potential litigation means, again, something that's real, that's discernible, that's actually possible right there, not something that possibly can happen." So, an example, you're considering your snow removal policies, for highway snow and ice clearance. Um, Yes, if you don't do it right, someone could possibly sue the municipality, but you're really talking about snow and ice clearance. That in and of itself does not trigger the litigation or potential litigation. The wording, of course, litigation means, I think, anything that's currently being litigated, and potential litigation means something that has a real prospect of being litigated. So, for instance, you get notice. If you pass that sign bylaw, I'm going to make a charter challenge. That's pretty clear. Or you can just think about it. You want to pass a zoning bylaw, and the applicant says to you, "If you don't pass it this way, I'm clearly going to take you to the ALPAT." So those are examples where you have it in writing. It's pretty clear that you may be facing potential litigation, and you could go under this. So it has to have a reasonable prospect of litigation actually occurring. And the exception has, like a lot of them, been very narrowly interpreted in the past. It generally will not apply generally unless a proceeding has been or is very likely to be commenced. And the very likely is when you have someone who puts it in writing for you. I mean, that's a really good example. It's not the only instance, but that's a good example of when it could possibly happen. Next slide, please. Solicitor client privilege, that's when you go in and you may get advice from your lawyer. There's a three-part test to that, and I've set it out. I won't belabor it. It's right there for you. It's not necessary for your legal counsel to be at the meeting. I've often, and I'll admit, probably pre-pandemic, used to often provide opinions to counsel, and they would say to me, we don't want to have to necessarily pay you 2 hours to get here to our meeting, only to be there for half an hour and then have to drive back. I get asked a lot more now to be at closed meetings because it's easy to get me in on them. But it's not necessary for the lawyer to be there. Counsel can still receive communications from legal counsel on a matter and get an opinion, and the solicitor-client privilege could continue to apply. So the lawyer doesn't have to be there, nor does the mere presence of a lawyer at the meeting serve to satisfy the exception. So it has happened that some counsels have said to me, why don't you come to the meeting and then we can shelter you as a closed meeting matter under this exception? I say, that's not really appropriate. If I'm really giving you advice, that's one thing, but that's an improper use, and I can't be subject to doing something like that at counsel. That's as an officer of the court, I just can't do that. And so the mere presence of a lawyer doesn't serve to imbue the authority to meet under the solicitor-client privilege, nor does the fact that the lawyer is absent serve to oust it from being a proper meeting held under this exception, under Clause F. Next slide. Closed meeting under another statute. For years, I thought there was really only one here, and that was the Emergency Management Civil Protection Act, something that you probably are now quite familiar with because many committees and councils had to meet last year and probably still meeting on emergency plans. Also, I put in the Police Services Act. There was one that I found there. So as you know, Police Service Board is a local board for certain purposes, including the open meeting rule. So they do have to meet, but there is an exception. Next slide, please. Here's the four new ones. So I'll speak about these a little bit. Confidential information supplied by another level of government, including a crown agent of Canada or the province of Ontario, or I suppose another province, giving you information. The information has to be explicitly supplied in confidence. Okay, so the government has to actually say we're expressly providing it to you, or it has to be marked confidential, whether it's watermarked or it's labeled that way. But there has to be some express provision of it as a confidential information matter. Next slide. Third-party information. I've talked a little bit about this. I'm not going to belabor it. It has to fall within one of those categories. So it has to be a trade secret, scientific, technical, commercial, financial information, or information relating to labor relations that is provided by the third party. This is really to the benefit of the third party, as it is under Section 10 of INFIPA. And the reason being there is some people would not provide responses and would not provide information to the municipality if some of it wasn't protected to again, protect their place in the commercial marketplace and their bargaining position. So this is why the third-party information exception is there. It has to be supplied in confidence. Notice that it doesn't say explicitly supplied. So I guess it can be implicitly supplied. I always suggest to people, if you're going to try to rely on this provision, just say it. just come out and say this is confidential. In fact, most RFPs will say, you have to tell us exactly what it is that you want to protect. And you just can't protect everything that comes. You have to protect only that type of information. Of course, it also has to be reasonably expected to significantly prejudice the commercial competitive position or significantly interfere with contractual or other negotiations. So there's a number of strictures, and a lot of these tests have already been determined under MFIPA. So anytime that your clerk is suggesting to you that you may be able to go in camera on this provision, or council itself would like to go, or committee would like to go into a closed session, there's a lot of brain power that goes in behind the scenes to try to determine, is this properly something that we can go in camera to consider? Okay. The next one. Is this the next? Yeah, the next slide. So trade secrets. So I have a number of slides now that actually go back. So can we go back one slide? I've set out 6 categories. The next number of slides, and I won't go into them in the interest of time and leaving some time for questions. I won't go into them, but there's a number of slides that then articulate what each of those things means. So trade secrets, scientific, technical, and so on. So let's go to the next slide. This is the one that speaks to trade secrets. Then there's the next slide and so on. So can we get to the one that says third-party information, reasonable expectation of prejudice? I think it's the one before you have up there. Yeah. And there's an actual case that talks about what a reasonable expectation of harm is. So I just wanted to point that out. It's not the mere possibility, or again, speculation. There has to be a risk of harm that's beyond that, and that's for the third party to bring forward. So has to bring forward demonstrable specific evidence rather than something that could be possibly out there, like a loss of reputation or something that can't really be proven. Okay, next slide. Municipal information of monetary value. So this is, again, the corollary. This is under J. It's the 10th one. This is information that protects the municipality. And this exception applies when this information is under discussion. And so I showed you the categories. Notice that there's one whited out there or grayed out. I put that just to show you the example. It's the same types of information, proprietary information, but it excludes labor relations. And I think the reason it excludes it is because it has labor relations itself is dealt with earlier on in its, I think it's in D, labor relations and employee negotiations. And of course, MFIPA has some specific provisions dealing with labor matters, I think in sections 52 or 53 of the Act. So this is information that belongs to the municipality or the local board. It has monetary or potential monetary value, economic, financial value to the municipality. The exception, of course, is based on the value. Could the information that comes out possibly be sold, or could it possibly be used to the detriment of the municipality? That's the test. The exception here does not apply to the allocation of funds or to financial information in a general sense. It's specific information. Next slide. And finally, positions, plans, criteria that are used for negotiations. Again, like the very first one, which was the security of the property of the municipality, and the third one, which was the sale or acquisition of property. The purpose here is to protect the municipality's assets and to protect the municipality's bargaining position. And here you've got, again, a multi-part test. So some of these things aren't easy easy to discern sometimes whether the exception actually applies or not. But you have some guidance here from the Information and Privacy Commissioner. And in Order M92, so it's a municipal matter that the Information Privacy Commissioner considered. It formulated a four-part test, and I'll leave that to you. I won't go into it. Okay. Next slide. And again, here's the exception, just a little further elucidation as to some of the intricacies of this particular exemption. Okay, next slide. Here are the additional exemptions. As I mentioned to you, there are two exceptions under sub 3 of the Act. These two are both mandatory. That means there is no discretion. If the subject matter deals with either of these two things, then they have to be considered in a closed session. The first one doesn't apply to you, but it's when counsel is the head making a determination under MFIPA. And I think in your case, in both the local as well as Peel Region, you've delegated the authority, you've designated someone to make those decisions. So it's not counsel itself acting as an administrative decision maker making those decisions. So A wouldn't apply, but B could apply, and that relates to an ongoing investigation. So it has to be something that's ongoing, where there is an investigator that's been appointed, like a closed meeting investigator, and council needs to consider it. So in my realm as a closed meeting investigator, I may provide a draft report on a closed meeting investigation matter. And if I provide it in draft, council is entitled, and in fact, if it's going to consider it, then it's mandatory that you consider that in an in-camera setting. So those are two exceptions. Unlike the other ones, which are all discretionary, this is mandatory. Next slide. And finally, the very last exception is the one for education or training purposes. And it says you are entitled to meet, to have a full and frank and open discussion in an education and training closed meeting session, but you cannot in any way deal with the subject matter that actually deviates from education and training to actually talking a matter and trying to move it forward. You can't do that. Materially advances, I've put in the first bullet at the bottom, means significantly advances. So again, it's a permissive authority. If you want to have an education and training session, like you're having today with me, you're having it in a public setting, and you're fully entitled to do that. You do not have to have it in a closed setting, but you could. And in some instances, council relations, matters of possible, harassment or incidences where you're talking about things like that, you may want to have those discussions and those training sessions in a closed setting, and you're entitled to do that. Next slide, please. Here's the one. You have to be very careful. If you're going to have an education training session, then the only purpose is to deal with those matters. So I'm going to be very careful after I'm taking questions to, the questions do have to be hypothetical. You can't be asking me questions on matters that are going to be coming up at council. Now, I won't know that, so you're going to have to help me police yourselves on some of that. So the only thing that you can talk about in a training session is actually related to the training session. That has to be the sole purpose of it. And the Oshawa report made that abundantly clear. There's been other number of reports by other closed meeting investigators that have said the same thing. Next slide, please. Here's a matter that has come up, and I just thought I'd bring this to your attention. There's actually a case from the divisional court where the council was challenged because it said, well, you were dealing with something, and parts of it were properly closed meeting matters, but other parts of it weren't. You should have gone back into open session. And the court here, I think, takes a very pragmatic view and says, you know what? It is very difficult when you're doing this and having a meeting to hop in and hop out and hop in. So the court says if the matters are inextricably connected, you may be entitled to talk about something that is a closed meeting matter, and then maybe deviate a little bit, still with a related to that item matter that maybe should have been in an open public session, but instead of going in, coming back out, the courts have recognized that that's difficult to do. Maybe not as difficult now with virtual. Maybe even more difficult. I'd have to ask somebody about that. But you are entitled to, and so there isn't. If you're talking about 8 things on one matter. That's properly closed, you may be possibly able to talk about a couple of ancillary things that maybe you should have gone in open session. I think what I would recommend there is then if you do talk about a couple of things that should have been in an open session, then you do report out those things at least, if you can. If you can't, and it would actually derogate from the reason why you went in camera, then of course there's a reason why you don't have to report that out. So wanted to bring that to your attention. It's a question that I'm often asked is, do we have to, all of a sudden adjourn, go back into open, and possibly, we have another go back? And no, you don't. Next question, next slide. Authorizing resolution. So here, I'll talk about a little bit of the procedural requirements. The law says in the Municipal Act, before you go into a closed meeting, it's mandatory for the entity, council, local board, or committee, to state by resolution at the open public session that you're doing so, that the meeting is being closed and the general topic that is to be covered. And in the second case, if it's for education and training purposes, then you have to state that and say that you're going in there for those purposes. I know it sounds a little superfluous, but that's what it actually says. So you have to have a resolution of council. So I go back again. Who has the discretion? Simply because an item may be listed as a closed session meeting matter, it still is up to the council to make a determination at the council meeting whether it's going to pass the resolution to go in camera. And so you have to do it. So I can't say other than the discretion is with council, the local board, or the committee to make that decision at council. Next slide. The authorizing resolution. And I've quoted from an Ontario Court of Appeal decision. This went all the way to the Ontario Court of Appeal. It dealt with the naming of the public market square in the city of Kingston. That's what the matter dealt with. The resolution, the court said, to go into closed sessions should provide a general description of the issue to be discussed in a way that maximizes the information to the public while not undermining the reason for excluding the public. So the court says this isn't easy sometimes. It's tricky. You're supposed to try to provide, in the interest of openness, accountability, and transparency, as much information as you can. But for instance, in my example about going into a closed session for a pending acquisition of land, if you were to name the land, that's a problem. So how, that would undermine the very reason that you go into closed session. So in that case, it would probably be appropriate to say something that a resolution be passed to go into closed session for council or committee to consider the proposed acquisition of lands pursuant to the provision of 239 2B. I think that's the one, or C. so that would probably be sufficient in that case. In other instances, you might have to be a little more open and a little more forthright about what it was that you discussed in camera. Uh, a resolution that simply reiterates the wording of the applicable closed meeting exception will likely not suffice. Now, I took that wording, that isn't the exact wording, but I've tried to pare it down and give you a synopsis of what the Court of Appeal actually said. So you should try to stay away from just repeating without anything else, just the wording of what the closed meeting exception says. It may be appropriate in certain instances, and it's likely inappropriate in the majority of instances where you should provide just a little more information to the general public about what it is that you're going into closed session for. Okay, next slide. Limited voting. There is an ability, of course. Section 244 of the Municipal Act says all voting shall take place in an open public session. However, it is possible to have some votes at a closed meeting. And the two requirements under 239(6) are conjunctive. Both of them have to apply. The first one is this. The first one is you have to actually be speaking about and taking a vote on something that's properly in the closed meeting. So it has to be for a proper subject matter that is allowed under 239, whether it's 239 sub 2, sub 3, or 3.1. And the vote has to be for a procedural matter. So to approve the minutes or the notes of the closed meeting session, for instance, or for giving directions or instructions to officers, employees, or agents of the municipality. So people often get this confused, and I've seen this, and I've actually had to write a couple of opinions on this. Notice that the last bullet, the vote is for a procedural matter or for giving instructions or direction. And I think some closed meeting investigators in the past have said you can't have a substantive decision in a closed session. And I say that's wrong. And I think what they've read is for a procedural matter, and they've said, well, if they meant to say a substantive matter, they would have said so. I don't think that's how it actually applies. However, you have to be very careful when you're talking about making substantive decisions because you're supposed to be making that in an open session. However, and I'll give you an example of this. You have a litigation matter. Someone has sued your municipality for many millions of dollars. And what you'd like to do is settle it. And council has to make a determination, or committee has to make a determination. You're going to instruct your legal counsel to possibly strike a settlement. But you don't know what the settlement is yet. But you have to make a decision on what parameters to give them. So, in my view, aren't you making, in a sense, a substantive decision to settle? And two, possibly for an outside upper limit. I say to you, there is nothing wrong with that. This wouldn't work unless you could do that. So, I say those closed meeting investigators that in the past had said you can't make a substantive decision, I think I know what they meant to say, but I don't think the way they applied it was correct because I think council or committee may have to make a substantive decision in order to give instructions to and directions to your legal counsel, to your CAO, to your planning director, to your treasurer. You have to be able to do that. The difficulty here, and this is where it gets really, really dicey, and this is where you really need to get legal advice sometimes, is you can't just say, oh, we're giving direction here, but you're actually really just going ahead and making the substantive decision and then cloaking it in the guise of giving direction. And I spoke to a clerk yesterday who said to me, I can think of just about any possible way the council could make a substantive decision, but then seek to dress it up as direction. And I said, and that's wrong. That is absolutely wrong. So this is probably one of the most difficult things to do. But I would submit to you that a vote that where you have made, for instance, a decision to settle litigation for X amount of dollars is appropriate if you're giving direction to your CAO, to your city manager, to your regional manager, to your legal counsel to go ahead and put that in place, and then to come and report back. I think that's completely appropriate, but I also understand how difficult it is to make those distinctions. Okay, so that's probably some of the deepest things that I'll try to impart to you today. And I don't want you to take away from this that, yeah, in camera you can go now and make completely all of your substantive decisions. That is not at all what I'm saying. So please, please don't misunderstand that point. Next slide, please. The effect of improper vote. Well, again, I go to Farber from Kingston. The court made a very, very curious decision. It didn't say, well, anything that was voted on that you couldn't vote on then taints everything. The court actually looked at it quite differently. And I've got to say, I've tried to wrap my head around this, and I really have some difficulty with what the court said. I'm not imputing that they made a wrong decision, but I really have some difficulty. The court said in this particular case, the failure to pass the necessary resolutions and the unauthorized vote were at most procedural irregularities unconnected to the real decision to pass the bylaw. They do not taint its legality. What is key here is the court found that council voted inappropriately to actually make the substantive decision in camera, but it did go out and have a full discussion in an open session and actually did then take a vote in the open session. So that's the distinguishing feature here. And I think anyone that takes away saying, oh, we're allowed to vote illegally, it doesn't really have any consequences, I think that's wrong. So a bylaw, I say, a bylaw that's passed in a closed session may be voidable, but it doesn't make it void ab initio. That means it doesn't make it void from the start, especially if council comes out, discusses it, has a debate in an open session, and then takes a vote there. That would, I think, serve to put it back legally into its proper course. Of course, that's not generally what happens. The vote may be taken in a closed session, and it's tainted with illegality because you're not supposed to vote on that substantive matter, and then there is no discussion in an open session. In fact, that's kind of the RSJ Holdings versus City of London case from the Supreme Court of Canada from 2006, 2007. Next slide, please. I've talked a little bit about this, and I won't belabor it. Who can attend a closed meeting? Well, all members of council are entitled, unless they're somehow disabled. So when I say disabled, the Municipal Conflict of Interest Act says that you actually, I think it's section 5(2) sub 2 of the Municipal Conflict of Interest Act, you actually have to absent yourself, leave the session, the confines of the closed meeting, if it's a matter in which you've declared a pecuniary interest. The second one is if you are otherwise disabled. And this one's a little curious because the law is that a municipal councillor isn't necessarily a normal administrative decision maker. In fact, you are allowed to take hard positions on things. The only thing that the law says, unlike a normal decision maker that can't be biased in any way, can't even have a reasonable apprehension of bias, the Supreme Court of Canada has said some form of prejudgment is inherent in the role of a municipal councillor who has to express the views of their constituents and to fight for them. So it's fine for a member of council to have a hard stance on something, but the only thing that the member of council can't have is a closed mind. And so you have this odd odd bias test in the case of a municipal legislative decision making. For instance, to enact a bylaw, to grant a license, other decisions that you may make in the normal course as a member of council. As long as you don't have a closed mind, as long as you're amenable to persuasion, you're entitled to make a decision, and you're entitled to sit there, even though you have a very hard line. So please don't ever say anyone, I have a closed mind on the matter and I'm not capable of being persuaded. Because if you say that, you've tainted it and you've created bias, and you're not supposed to vote. So if you have that bias, you are supposed to recuse yourself. So if you are recusing yourself, you shouldn't be at a closed meeting. And the reason being is no one except the people there know it. So there's no transparency to the matter. Conflict of interest, I've also put, and that's not conflict of interest under the Municipal Act. It's conflict of interest under your code of conduct. So you have an apparent or a perceived conflict of interest that's personal or private in nature, not financial in nature. Okay. The other person, of course, who has to attend a closed meeting is the clerk or someone else that's been delegated by the clerk, because someone has to take notes. There is no obligation for you to record, whether audio or video, your closed meetings. Many councils have said, no, don't want to do that. I want to have a full and frank discussion, and it might be inhibited by doing that. I'll speak to that in a moment. And of course, other people may be able to attend, like staff, consultants, agents. It's at the pleasure of the council or the committee that's having the closed meeting who gets to attend. Just be careful that if you do ask some people to attend, and the purpose of the exception is to protect your bargaining position, but you have the person who's opposite you at the closed meeting, then you've lost the exception there, and all of a sudden you may not be able to be in camera. Okay, next slide. Record keeping, again, no requirement for audio or video recordings. The Ontario Ombudsman has for many years, I think since 2008, recommended that all meetings need to be recorded, and he recommends video recording. Look, it certainly helps a closed meeting investigator. You don't have to go and interview everyone at the meeting. You can just see what happened at the meeting. But does it really serve the interest of having a closed meeting if you're audio or video recording it? Perhaps not. So you have to have someone there who takes at least some notes, and without note or comment keeps a record of the resolutions, decisions, and other matters, including votes that have happened at the closed meeting. Next slide. Oh, and I've already talked about this, so next slide. The contents of a closed meeting record. Here is what your clerk should be keeping track of. I won't go through each one of these. They're pretty common. The Ombudsman puts out a really good, I believe you've been provided their Sunshine book, and have a nice little synopsis of what are the contents of a closed meeting record. When we're doing closed meeting investigations, these are the things that we often will look for, and we'll ask the clerk for these things, including certified minutes and any bylaws or anything that may have been passed, any resolutions. So I'll talk now. Oh, sorry, next slide. So I'll now go to closed meeting investigations, a new authority that was put in place by the Bill 130 amendments, but they didn't come into place right away. I believe the other Bill 130 amendments came into effect on January 1st, 2007. There was a 1-year delay. The ones dealing with closed meeting investigations didn't happen until January 1st, 2008. Any person, it doesn't just have to be a resident, can request an investigation as to whether the meeting was properly conducted, and it was done in accordance with the requirements of Section 239 of the Municipal Act, or with the requirements of the municipality's procedure bylaw. And there's 2 investigators. There's an investigator that the municipality has appointed, and I indicated that Peel Region has appointed LAS, and via LAS it's Airden Burles, or your default would be the Ontario Ombudsman. The municipality, of course, must comply with Section 239. It's statutory, and then, of course, its own procedural bylaw. Here, it's where the legislation seeks to hold your feet to the fire because any person can come and make a request. Now, person, again, very broad, includes a corporation. But I've often had community groups file it, and I've often said to the clerk who sent me the closed meeting request, is this an actual legal entity? Because if they're not incorporated, they may not be able to make the request. A person can do so, a corporation can do so because they're defined as a person under the Legislation Act, but not just any association can do so. Next slide. The closed meeting investigative procedure is the investigator is entitled to have such powers as are assigned to him or her and as given under the Municipal Act. And there are three things that the investigator really has to keep track of and to adhere to. Independence and impartiality has to be independent and impartial. I've often said just because we've done work for a municipality does not mean that we're not independent and impartial. We'll always run a conflict check at the firm to make sure that there is no issue. And if there is any issue we will delegate our authority to do so. Confidentiality. So the whole thing is done in a confidential mode. The name of the requester is not made known unless the requester, him or herself or itself, discloses the fact. We're supposed to do it confidentially, and we're supposed to carry out the investigation confidentially, including any persons that we deal with. And finally, the credibility of the investigator's investigative process. So what we seek to put in place is a scheme of procedural fairness and afford procedural fairness to everybody, including the municipality that is being called into question about what they did. We afford the municipality the ample opportunity to respond, and that includes providing a report where we find that there might have been a contravention of the act or of the procedural bylaw, so the municipality can comment. Next slide, please. I've already said a little bit of this. The investigations are conducted in private. Investigator may hear or obtain information from whoever the investigator thinks is appropriate. Has the ability under Section 19 of the Ombudsman's Act, which is quite a big authority, can get any officer, employee, or member may be compelled to provide information to us, and so on. The investigator, by the way, is not a compellable witness if there's any challenge to any of this. So not a competent or compellable witness. Next slide. Here's the steps of a closed meeting investigation. It usually starts by a formal written request made by a person. There are no time limits set out. I had recently a municipality that said, well, we've passed a policy and we will not accept any requests for a closed meeting investigation beyond 6 months from the date that it's filed. And I've said to them, I don't think that's appropriate. There is nothing that limits the ability of someone to ask for this except for the authority under the Municipal Act, and it didn't exist before January 1st, 2008. Apart from that, I don't think that a municipality can say you only have 6 months or you only have 2 years in which to go back. And believe me, we have gone back like 12 years to do a closed meeting investigation. It's not fun, but I think that's what the legislation permits. This is very much unlike an investigation or a complaint process for a code of conduct matter, because the municipality itself, in that case, is given the authority to establish a code of conduct and a complaint protocol. It's very different under this different part of the Act, under 239.1 and .2. There is no time limit. So the investigation commences by a request, a bona fide request. We will dismiss summarily requests that are pure fishing expeditions. And I've checked with the Ontario Ombudsman. They've done the same thing. We had one recently saying the municipality asked for a minister's zoning order. How could they have done that except by a closed session. We don't know when they asked, so we'd like you to go back and look through the last 2 years of the council meetings. And we said, we're not doing that. That's a fishing expedition. You have to tell us where you think this may have gone awry, and that's not good enough. And the Ontario Ombudsman has said the same thing. What we actually do is we try to scope down the request, just the same way that a head would do so with a requester, a person filing a request for freedom of information. When they, put in those broad requests, there's a requirement in MFIPA where the head is supposed to try to help out the person to try to scope it, to get it, narrow it. So we try to do the same thing. Sometimes the requester doesn't want to do that, and we just don't deal with it. And we say we have the entitlement to decide that it's not a valid request and we won't deal with it. There's an initial intake. There's a review or assessment as to our jurisdiction. I'll give you one example. We have one that's very contentious, where the request is made of this entity, and the municipality maintains very clearly it is not a local board. The requester maintains very strongly it is a local board. So we've actually had to do a preliminary analysis. We have to make a legal determination in order to know if we have jurisdiction, whether it is a local board or not. So sometimes these things do not move quickly because you have to make these initial assessments up front. The municipality, if it doesn't come through the municipality initially, is notified of the request, usually through the clerk. There's a field investigation, which means that we look at materials that the clerk will send us. We'll review all of the records, including the notes of the closed meeting, any audio or visual recordings. We may interview people that were at the meeting. And you can understand why this sometimes gets very cumbersome, very administratively complicated, and also unfortunately expensive, because if you have to interview a lot of people, there's just a lot of people to interview and a lot of time spent on it. There's a determination of findings and the preparation of a draft report that is then shared with the clerk and the municipality, and also sometimes and usually with the requester. Then there's the delivery of the final report, and sometimes we're formally asked to attend and speak to it. Sometimes we're not. Sometimes when we do recommend that the municipality has perhaps not done the right thing, we often recommend training, and certainly we've done that. If there is a contravention, then we do have to report, and council must pass a resolution as to how it intends to address the report, and then finally the report is made available to the public. So there's a spotlight shown on the matter. Next slide, please. Reported recommendations, there you go. That's the authority that after undertaking an investigation, if there is a contravention, then there has to be a public report that has to go forward. There are no sanctions or penalties that a closed meeting investigator may recommend, nor that council can impose, or that anyone can impose for council's possible breach of the open meeting rule and the procedural bylaw. Next slide, please. Publication of reports, they have to be made public, and that's usually by posting on the website, also through the council agenda. But it's always good to have them in one place for the public to look. And I have always recommended to municipalities to have a web page on closed meetings and any reports that have been made in the past. And a new requirement that came in through the Bill 68 amendments, that is that council has to, or the committee has to, pass a resolution as to how it will deal with the recommendations. And I think the province put this in because when there were some contraventions found and reported on, the municipality would say, great, okay, we'll accept the report, we'll receive the report, and then not do anything about it. The province has now said you actually have to have a statement, pass a resolution exactly on what you're going to do about it. Next slide. So I just want to very briefly talk about electronic transmissions. The Ontario Ombudsman, in a long number of reports, and a number of closed meeting investigators have said, you can have an improper meeting by electronic transmissions, and that could be texts, chat rooms, emails, even serial telephone calls and messages, including teleconferences. And the point is, if there is a gathering, if there is a get together of more than a quorum of council, through any of these means, you could possibly be creating an improper illegal meeting. So it is inappropriate for a member of council to say and send out an email to all the other members of council and say, this matter is coming up, next meeting or, next month. I'd like to get everyone's views on it to see, where we're going with this. As soon as someone chimes in, you've got an illegal meeting, and that's inappropriate. It completely militates against the openness and transparency of the open meeting rule and proper municipal decision making. So Zoom, Teams, FaceTime, Skype, teleconference calls, chat rooms, texts, direct messaging, emails, all of those things. If you have people chiming in with their opinions, you may have an illegal closed meeting. And the ombudsman was very clear on a bunch of those. Now, I want to say the ombudsman did a little bit of an about face, and I don't think the ombudsman was correct. Wrote a report in the city of Hamilton. This was at the beginning of 2019, if I'm not mistaken. Yes, I think it was the beginning of 2019. Might have been the beginning of 2020, so I correct myself. What happened here is the city clerk sent an email to council and senior staff giving general information about a vacancy in the council seat. The councilors started to exchange emails trying to reach a consensus as to what they would do. Are they going to appoint? And who are they going to appoint? There was no consensus reached. The ombudsman made a really curious decision, though, said, well, this wasn't a meeting because to have a meeting, you have to have a quorum of members who are physically present. Don't think the ombudsman was correct in that. I looked at it quite differently. I didn't look at it as, is that a meeting as defined under the Municipal Act? I looked at it as, hold on, does this actually take away from openness and transparency as it's supposed to be conducted under 239? And I kept coming to the conclusion, yes, it does. So my view is 238, the meetings provision, has to be interpreted. Sorry, next slide, please. And the next slide. Sorry, I got a little ahead of myself there. Section 238 should be interpreted with a view to the purpose and the legislative intent, which is to increase accountability, transparent, and public confidence in the integrity of local government. So my view, members should not be emailing or texting or chatting with one another. Especially if those numbers are more than a quorum of council. So here's the difficulty. You decide, I'm not going to email, the majority of the members of council. I'm just going to email 3 or 4 persons. What happens if those persons then send out a chain email with the views as expressed by those 3 or 4 people or 2 or 3 people, and then all of a sudden you've got other people who are seeing a chain email with the views of everyone? To me, that's an illegal closed meeting. And so please, please be careful if you're emailing people because you don't know where it's going. And I would think there may be, I haven't seen a case recently on this, but I think there were cases from the Ontario Ombudsman before talking about serial emails and chain emails where you have more than a quorum of council expressing views, expressing opinions on matters dealing with the business of council, and those are illegal meetings. So please, please be careful of that. Next slide, please. And I'm getting towards the end. Reporting out of closed matters, practices vary really widely from municipality to municipality. I'll have to say it's not legislated. There is nothing that says you have to do this. And therefore, there's also no bright line test. That means I cannot tell you today that to report out on any specific matter, you have to do exactly this, this, and this. And you have to say this, this, and that. I cannot do that. Each one is individual, and you have to make a determination what's appropriate. Next slide. And I will rely on the Ontario Ombudsman, who has said in at least 2 decisions, and I have the quote here for you. And he used the same quote in two reports. I encourage councils to report back on what occurred in camera, at least in a general way. In some cases, public reporting may consist of a general discussion in open session of the subjects considered in closed session. This might be similar to the information in the resolution authorizing the session, together with information about any decisions, resolutions, or directions given to staff. However, the nature of the discussion might allow for considerable information about the closed meeting to be provided publicly. So there is some guidance there, but notice that you have to make a case-by-case determination, and there is no one proper, correct way to do it in each individual case. I think the courts have said very clearly you are to try to give as much information as you possibly can without possibly undermining something that still needs to be remain in a closed session, and there might still need to be some protection of that confidential information. Next slide, please. Reporting notes or records of the closed meetings can be and probably should be adopted by council in a closed session. Some councils, adopt it in an open session, but I think those are councils that don't actually report out all that much, and their closed meeting notes don't say that much. But you can imagine if you have closed meeting notes that talk about exactly what happened in camera, it may be a problem to have those approved in an open session. So I don't think there's anything wrong with doing approving those notes to then report out so they can be put on a public session and doing them in closed. In fact, I think the Ontario Ombudsman recommends that. The notes records should remain confidential, like the background materials there, and so on. Next slide, please. So I'm going to, these are the last 2 slides because I want to leave a little bit of time. Common problems. There is no closed meeting exception that's applicable for the discussion that council wants to have. Just because something is controversial, just because something is sensitive, does not mean that council can go in camera. You have to find an authorizing basis for it in 239 sub 2, sub 3, or 3.1. Sometimes you will say, we're going in camera to discuss this, but you're not. You will end up discussing something else, and that may be a problem. Also, what happens is you're in camera and you start to deviate. You're talking about the correct thing, but then someone brings up something else, and all of a sudden, you're not talking about the one thing that you agreed to you were going to go into camera to talk about. You're talking about something else, and that's problematic. The failure to comply with the procedural requirements, you don't pass a resolution before going in camera, could be a problem. That has happened occasionally, and I always recommend, as soon as that's found out, go into open session and actually pass it. So it can be done after the fact. I would not recommend it, but it could help. Improper voting, you can only vote on certain things. I talked about that. Improper, insufficient record keeping. So you can't then do a proper closed meeting investigation if you don't have the proper records and who was there and who may not have been there. And the failure to report out in an open session. It's always good to report out as much as you can, at least let the public know something that's happening. And finally, best practices. Next slide. Always try to provide sufficient notice of upcoming closed sessions if you can. Now, I appreciate you cannot sometimes because on the fly, something will happen. Council then still has to go through those steps, and you can, of course, decide to go in camera on the spot at a meeting. You can do that. That's not inappropriate, and it may happen sometimes. Probably happens more often than you think. And of course, just because something is listed as an in-camera item on an agenda doesn't mean that council has to agree that it's an in-camera item. The council has the discretion to make that determination. Second best practice, pass a clear resolution regarding the purpose of the closed meeting and select the proper closed meeting exception or exceptions that apply. There's nothing wrong with saying we're going in camera to talk about a possible acquisition of land and solicitor-client privilege, because those two could go hand in hand, or litigation, because what you may be settling on the litigation is the acquisition of the land. So you can have more than one that applies. I got just be sure you try to discern exactly which ones do apply, though. There is, of course, always the issue about staying on the topic. So please make sure that if you're having a discussion, you stay on topic. I find, in my experience, clerks have always been very good about this, and they try to keep you on the straight and narrow. So please listen out for your clerk saying, we're straying here from the discussion that we should be having, and then see if you can correct that. Now, of course, the chair always has carriage of the matter and should be cognizant of these things. Adhere to the closed meeting voting restrictions and limitations. Of course, keep a record of the closed meeting, report out as much as possible in the open session. And finally, closed meeting information should not be disclosed. I know that your own code of conduct provides that no member shall disclose the content of any closed meeting matter or the substance of deliberations of an in-camera meeting until the council or committee discusses the information at the meeting at an open session. I've often said that one of the worst things that a council member can do is to breach their obligations to the rest of council, to their fellow colleagues, by disclosing closed meeting information. You have a fiduciary relationship, an obligation to your electorate to not use that information in an improper way, and that includes disclosing it. So, Madam Chair, members of committee, I've reached the end of my presentation. I apologize and the initial difficulties getting the PowerPoint started, but I am available and happy to answer any questions that you may have.
Well, as I said, John, no apology required. We've been having glitches all day. You're not the only one.
Thank you.
First question is from Councillor Innes.
Thank you, John. Nice to see you again. Couple of quick questions for you and what you sort of think is best practice. I'm still a little unclear about the authorizing resolution or the resolution coming out. More so going into camera. So we follow a consent agenda. It's done through the chair and the clerk and legal. They basically determine for us what's going to be in camera versus what's not. And I understand it's up to council at the time of receiving the agenda that we could say we think that this should be a public discussion and have that. But A, I guess what would be the best course of action to do that? And B, is it following a consent agenda sort of protocol? Is that the best process for a regional council?
Yeah. Thank you. Through you, Madam Chair, and nice to see you too, Councillor Innes. Great question. Look, I think a lot of thought, in my experience, clerks really take this seriously, and they do go through with the chair or with the head of council to try to give good guidance going forward. Many times I'm called, because I act as general counsel to a number of municipalities, I'm actually called and asked about this. Is this something that can go in camera? Is this appropriate? Is this, what's the exception? Is it this? And I think you should take the guidance. And one of the difficulties that you have is, you may not know everything that's there because it all hasn't been yet disclosed to you. So it's always good to take the guidance that's offered, and if something is suggested to be in camera, that's a good starting point. But as I said, it is council or committee's determination and discretion whether you do go in camera. So the authorizing resolution has to be passed before you go in. So notwithstanding that it may be listed on the closed meeting, you still have to make that determination. And there may be some very compelling compelling reasons to go in camera, but there may be some very compelling reasons not to. And so at least that debate might have to occur. And again, it's one of those things where unless, I know exactly what the matter is, it's hard to give you the bright line test to say, this is the resolution that you have to pass.
Okay. And what about when you are doing in-camera rulings and such? I know the region appeals process is slightly different than the town of Caledon's, in the sense that our integrity commissioner's findings in the town of Caledon, their findings and their penalties are done and implemented at the time of their determination. At the region of Peel, the penalties get voted on by council, and some can see that as not putting council in a fair position to have to be judge and jury of their colleagues. What is the best practices around the province, and what would be your recommendation for our code of conduct in regards to RIC's rulings on those types of issues?
Yeah, through you, Madam Chair. Again, a really excellent question, Councillor Ennis. In fact, I was in court arguing a couple of weeks ago in the divisional court on a matter very much about this, and this specific question didn't come up, but the question came up: what is the authority of the Integrity Commissioner? Does the Integrity Commissioner actually make rulings? I believe that's the wording that you actually used. Does the Integrity Commissioner make decisions? I argued in front of Justice Boudin that Integrity Commissioner actually doesn't make decisions and doesn't make rulings. The Integrity Commissioner makes findings of fact and reports matters and recommends matters. Now, I happen to know in your municipality, because I've talked to your Integrity Commissioner many times. By the way, John Fleming, excellent man, and probably one of the most well-known of the Integrity Commissioners. You've delegated the authority to him, if I'm not mistaken, to impose penalties directly. That's very unusual. I think Madam Chair indicated that I was the Integrity Commissioner for 50 some municipalities. I've only been delegated the authority to actually impose penalties by 7 of my municipalities. One of them actually took it back because they didn't like the fact that I wanted to penalize them when they didn't feel it was appropriate. I said to them, you're politicizing the situation and the decisions that are being made. So one way of saving that or moving away from that harm is to imbue the authority with someone who's impartial, neutral, and independent. Your Integrity Commissioner. But I've often said the province hasn't mandated it. And yes, you can do so by the delegation authority in sections 25.1 to 25.5. But, it's really council's decision to make. But council should be making a decision, on proper basis, not on, the way the political winds may be blowing in the particular case. So I'm giving you, I know I'm kind of hedging my bets here, because as an Integrity Commissioner, sometimes I just don't want that responsibility. And I often say the province hasn't put it on Integrity Commissioners, but the council itself can. If it feels that it's in danger of making politicized decisions, then or the awkwardness of the whole thing of sitting as the judge on your fellow council member, maybe leave it to someone who's impartial and neutral. So those are my comments on that.
Do you think that part of the provincial review, that this might be part of their consideration?
Through you, Madam Chair, yes, it certainly could be. I think what you have seen in a number of municipalities are decisions being made not based on accountability, not based on integrity, but based on the fact that there's a certain number of votes with a certain member, and the rest of the council doesn't want to penalize them because they like to have that person on their side. That's the danger. The other way of looking at it is it's council's decision to make, and that's what the province has said. I think it will be if it's raised, and maybe an independent person to make those decisions is the appropriate way to go. I'm not advocating here that Integrity Commissioners be given that authority. I'm just saying that is a suggestion.
Okay. And then I guess my last question is in regards to your electronic transmissions and that discussion. So I guess one of the concerns that some of us have is just the size of some of the municipalities within the region of Peel. So, for example, Mississauga has 12 councillors. So, if they are discussing region of Peel matters at a council meeting, not just in emails to one another, they don't have majority. They're one short of majority. Are there any concerns in regards to furthering the business of council? Because I was always told that furthering the business of council or in camera discussions is always quorum, but you've highlighted some concerns in your presentation about going beyond that. You know, you have an email with 5 and you send it to somebody else, and then there's another 5 and now you're up to 10. And so just wondering what your thoughts are in regards to that.
Yeah, by the way, and through Madam Chair, I took that position clearly with the Ontario Ombudsman in the London case that I showed you before. I said you have to have at least the quorum. You can't, otherwise, an individual member of council, even a band of members of council, don't have any executive or legislative authority to do anything unless it's a quorum of council. So you have to have at least the quorum of council. The difficulty is, though, when you're having these emails or texts or whatever with other people, and there's the chance that you may, those may be forwarded to other people that you're not even aware of, and all of a sudden, something that you really thought was confined to 2 or 3 people could possibly be more, and that's where the danger is. And it could not even be the person's fault at the beginning, but that's the danger of having these correspondences. So, I'm not really sure how to answer your question about, the city of Mississauga, 12 people. I know that they're not a quorum, but I'm not really sure how to answer that other than to just go back to my statement before. Is you have to be really careful on those serial correspondences or serial records where it's not a live back and forth like a regular meeting, but it almost has the flavor of a regular meeting when you're able to see what everyone else is doing and what other people's opinions are. So it is moving forward, the decision making of the council or committee.
Yeah, and I just use Mississauga as an example. Caledon's the same in the sense that because there's technically five of our council members, 4 plus the mayor, we can't discuss regional council issues with the 5 of us because then we have quorum for Caledon because there's only 9 in Caledon. So whether you're working up to the regional or working down to the lower, I'm just curious about that. You don't want to breach that quorum rule either which way. And I find because of Peel's numbers and makeup, it becomes a challenge.
Yeah, sorry, Madam Chair. I'm sorry, Councillor. You've clarified a little bit. I'm sorry. I think I understand now. My view there is, if you're at a proper, I think, and I'd have to think about this. I'm just going off the top of my head now, so I want to think about this. But I would think that if you're at a Caledon meeting or Mississauga or Brampton meeting, and those people are meeting and they're talking about the local municipalities business, and yes, you may be referring to what may be happening at the region. I think you're fully entitled to speak to that matter at that sitting because you're sitting as the Caledon, Brampton, or Mississauga council members. You're wearing that hat at that moment. So I don't think that would be an illegal meeting, and you can certainly have those discussions at that meeting. I think that's appropriate. And I know it's a little bit artificial, but so are some of these other rules. I mean, years ago, the Ontario Court of Appeal had to weigh in on the question of pecuniary interest in the Dufferin and Orangeville case, where you had members of Orangeville Council sitting on county council at Dufferin and saying, well, we're talking about a really important issue to Orangeville, but also to the county. Can we do so, or do we have a pecuniary interest? And the court said, in general, a member of a body, the word body is not defined, but it should be given its broadest possible connotation. However, the scheme of the Municipal Act allows local members to sit on the upper tier, and therefore you can do that. So I would say that if you're sitting in your municipality in Caledon, or Brampton councillors or Mississauga councillors are sitting discussing their local business as the local municipality council, they can discuss what may be happening at the region, and you won't run afoul of those quorum rules because you're sitting at the local level.
Great. Thank you. Thank you very much for your presentation today. It was very informative.
Thank you.
And thank you, John. Just to clarify, at the City of Mississauga, we actually have designation on our agendas that says issues pertaining to the region of Peel, because often we ask our staff to look at a regional report and interpret it for us and tell us what the implications are going to be to our city. So I think what Jennifer's referring to is exactly what we do. We have been doing it for about a year. So, and I also don't think if there are 5 regional councillors out of 9 in Caledon, that those 5 can't talk about region of Peel issues either, because they're not a quorum for the region of Peel. They're 5 out of 24. But even if we were 13 out of 24, I still don't think there's a problem discussing with our staff issues coming up on the regional agenda. Do you?
Madam Chair, I don't. I agree with you. I agree with you on that. If you're talking about as the council of the City of Mississauga or Brampton or Caledon, you can talk about those things, even if there had been quorum reached, because you're talking about them at the local level.
Okay, thank you. I just want to make sure that was clarified, because I know our city clerk is the most meticulous person you'll ever meet. And when we're in camera, if one person strays off one step, she stops us. So I would have guessed she would have stopped us from doing it. Your next questioner is Councillor Sinclair, and then then Mayor Crombie.
Yes, thank you, Madam Chair. Through you, you mentioned I don't know, I didn't quite catch it, at 11E something about position plan, procedure, criteria, or instruction. And that seemed pretty vague to me. And while I was off council, I was watching Caledon Council, and they were going through a huge planning exercise called the Bolton Residential Expansion Study. And meeting after meeting after meeting, it was 2 hours in camera, 3.5, 4.5. They discussed the whole thing in camera. And from an outsider's point of view, the final decision seemed to come from nowhere. So how do you, that position plan procedure going in camera can mean almost anything unless it has a context. Could you comment?
Yes, through you, Madam Chair. Thank you, Councillor Sinclair. I would refer you, and I know I went through it quickly, but there's slides 36 and 37, and I set out the 4-part test from the Information and Privacy Commissioner on what is the analogous exception under MFIPA. You're right, though. This is probably one of the most broadest of the exceptions, where it does talk about, a very broad authority for positions, plans, procedures, criteria, but all that are related to ongoing negotiations. So, and in slide 37, I give a little bit more, I hope a little bit more clarity, where I indicate, the exception does apply to matters that deal with somehow financial matters, commercial, labor, other negotiations, and there has to be some evidence of an organized structure or definition of the course of action. Now, again, very broad, and the definition of plan is very, very open. But I think, to get to your point, what council should have done, perhaps, is after those series of meetings that went on for, I think, a pretty lengthy time, there should have been some really clear and comprehensive reporting out to explain how you got to where you got, or how Caledon got to where it got at that point. That would have safeguarded matters. It would have meant that Caledon Council could have talked about those things, and they probably were entitled to talk about those things. But I think what was deficient, perhaps, at least I'm reading this in, and if I'm wrong, I apologize, that at the end of the day, you were left to wonder, well, how did they even determine any of this? So the reporting out would have helped immeasurably, because there wouldn't have been any ongoing negotiations at that point. Presumably it would have been finished. So there should have been, some clarity and some comprehensiveness brought to what happened, so that everyone could understand why the decisions had been made and what had been discussed.
Okay, thank you.
Thank you.
Thank you, Ian. And Mayor Crombie?
Thank you. My questions are a little simpler and on a different note. What about when we're discussing competitive advantage for our cities or for the region? I mean, that should be proprietary information, but yet you refer to it as not a reason for moving into in-camera.
Through you, Madam Chair, to Mayor Crombie, I think it could be. It could be possibly information that you could go in under the protection of the municipality's information. Possibly, I'd have to know a little bit more. It's one of those that I'd have to say.
Okay,
well,
for instance, let me give you for example off the top of my head. For instance, say Mississauga wanted to brand itself as a music city, but we didn't want, or the region did, whatever, just an example. We didn't want anyone else to know that. So we wanted to discuss that in camera before some other municipality got the idea and did it ahead of us.
Yeah, through you, Madam Chair, I believe Mayor Crombie, I think something like that you could do. In fact, it's kind of like it's what Councillor Sinclair was just referring to as maybe plans. Now, it's not negotiation, so I'd have to think about it. But I remember years ago, I was an in-house counsel. That's how I actually cut my teeth on municipal stuff for a larger municipality in the GTA. And one of the things that they wanted to brand themselves as was the high-tech capital. And it's a little bit like the situation. I believe, if I'm not mistaken, a lot of those discussions were held in camera with our economic development people saying this is an important matter to us. The branding, the thought that we want to get high-tech firms here, create, what do they call them when you have those synergetic hubs? There's a name for them, but anyway, but I believe that those discussions, at least some of them.
Hubs, probably, accelerators,
Exactly.
innovation hubs, yeah.
Right. So I think you probably could have those discussions. Look, I'm just doing this from the top of my head. I think you can, so I'll stick with that for the moment.
Okay, is there anything preventing, I mean, counselors can go in and appropriate staff. Is my chief of staff an appropriate person? Because often, they'll have to do the follow-up on the in-camera meetings for me or with the rest of the council.
Through you, Madam Chair, it may very well be. Now, you might, your chief of staff, I get it. I think if there's a buy-in from the rest of council, I could see on some things that, they might say, I don't know, there's an extra person coming, just more people there. But if there's a reason for the person to be there, I remember as legal counsel for this municipality, I often had to go on camera, and sometimes I was wondering why. There was really no reason for me to be there, but they liked always having the lawyer present for some reason. It's fine. I didn't think more than half of the things that they really were discussing needed to have the lawyer present. So it really depends on the municipality. And I would think that if you think it's appropriate that your chief of staff be there, it's something that I think you could bring up to council, because it's at council's pleasure who attends those.
Well, so interestingly, my chief of staff usually does attend our in-cameras, and the regional chair's chief of staff attends the regional in-camera sessions, but the mayor's chiefs cannot at the region.
At the region, and I could see that being the case, that they don't attend at the region. Again, there's lots more members of council. Probably, I'm not sure if there's more staff, but certainly more members of council. You're probably just trying to hone in how many people are in the closed meeting to just make it a little tighter. To me, that's not surprising. At the local level, you can bring your chief of staff, but maybe not at the regional level. It would just mean three more people, right? 3 mayors.
I know they do sit at the back and they're I don't think the point was it was an extra person. Somehow it was whether they had privilege or not. I'm not sure.
And that would be up to regional council to decide.
Okay. And final question is there no avenue that council colleagues can have casual conversations, not in camera, but in private, just to bounce around ideas that we don't, for instance, maybe it's something frivolous and we just don't want to look silly to the public, but is there no appropriate venue for us to have a conversation amongst each other, other than even in the lunchroom? I know the clerks gets really nervous if we start talking issues when having our lunch.
Yeah, through you, Madam Chair. Great question. The Ombudsman has written about this numerous times, has said, I'm not trying to preclude members speaking to one another because that's what they're actually supposed to do. They don't always have to do it in an open session. And he, of course, also says, I'm not trying to cut back on the socialization because that's a real important thing for people. You see this probably more these days. I know I see it with my associates. I don't get to know them as much because now I'm only seeing them over a screen. You don't have that connection with them. So to you, Mayor Crombie, I don't think there's anything wrong with you having conversations on a social basis with anyone. And I've often said the annual holiday party, the summer get together, as long as you're not actually discussing, council business. And that's the
But sometimes you are, right? Those are the things
Yeah.
you have in common. And then you're going to caution me that it can't be with a quorum amount of councillors. So, but I'm asking you directly, is there no forum that the 12 of us can sit there and just talk?
No.
Right.
Simply
Okay,
said,
that's it.
no.
That's it. Thank you.
Well, John, that's good. Not too many people say no to Bonnie. Great no without an explanation. That was really well done. If no one else has a question, I'd like to ask one that's been bugging me, not because I think it's wrong, just because it doesn't seem to fit any of these rules. When we have committee of adjustment discussions, and the committee of adjustment, they have hearings and they make their decision, individuals decide to appeal those decisions. What happens is they come on pink sheets in camera, and we discuss in camera whether we're going to support the committee of adjustment with sending a lawyer to the case, or whether we're not, or whether we're going to let them just fight it out. The original decision is made in public. The notification for the appeal is in public. It's a public document. I don't understand why we discuss it in camera, because all we're hearing from is our own staff telling us exactly what they said at the Committee of Adjustment. And you're hearing the local counselor probably give you a little bit more color. But I don't understand why those are in camera. Because when we go out, we definitely say address such and such, address such and such. We will be sending a lawyer. We will be supporting the Committee of Adjustment. So we make it very clear when we come out of the in camera. I'm just curious as to why we go in there in the first place.
Well, Madam Chair, I think you go in. First of all, I think the exception is litigation or potential litigation, which includes administrative tribunals. So if there's going to be an LPAT appeal, you may want to say, look, we're gonna consider this, and you may be able to do it. Well, you are entitled to do it, I think, as a potential litigation matter in camera. And, you may have all sorts of considerations. This may be a matter that's precedent setting. So then you decide we do want a lawyer to go and put forward the position or to counter the position of the applicant, whatever. And in some other cases, you may say, this isn't really a precedent setting case. This isn't material. We shouldn't necessarily need to spend the municipality's resources to go and fight this. So I can see why you would want to have that discussion in camera. Having said that, you're not bound to, and you don't have to do that. You could have that discussion in an open session if you'd like. But I think the reason that you do go is it is something that you're entitled to do. And there may be some sensitivities, I suppose, with making decisions in some cases to put forward a lawyer to fight the case, or even hire an independent planning consultant to give evidence because it's that important. And in some other cases, it isn't, and maybe you don't necessarily want to air that in public.
That's interesting because I'm a former teacher, and I always think it would be a teachable moment to have the discussion in public. So the next one that comes along and decides that they're going to appeal to LPAT, a decision of the Committee of Adjustment, they might listen to these debates and not do so. That was my first question. My second and last question is we had a case here in Mississauga or in Peel where there was a gentleman who decided to donate land to the region. And there was no cost to it. There were a few legal agreements to be arrived at. We went out of the in camera, we voted in public. Why was a donation that's not, the price wasn't changing, it was for free? Why was that in camera? And why, when we came out of the in camera, could we not state the property and the fact that we were accepting it?
So that's a loaded question because I am aware that there was a recent Integrity Commissioner report, I think on perhaps this matter. So I'm going to be really careful about how I answer this. So first of all, you're talking about a proposed acquisition. The acquisition may be for free and maybe a donation. And you decided to go into camera to discuss that. And that information would have been, I think, confidential. It would have been in-camera information. And so you could have gone and reported that out, but if you didn't, I don't know that that anyone could disclose that because it was still imbued with the confidentiality.
No, I wasn't asking you that. That would be a loaded question. I'm just asking you in future, if we get someone who comes along and wants to donate land, is that a subject that we can do in public session, or is that a subject that always has to go in camera? There's no cost.
Yeah, Madam Chair, you do not. I'm sorry, I didn't mean to interrupt you.
That's all right.
I was going to say, yes, you can't. Again, it's discretionary. You could have had that discussion in an open session. Wouldn't have been a problem. The person who was donating could have said, I'd like it to remain anonymous. I don't want anyone to know about it. So it could have asked that, and that might have been a reason. But no, you could have just gone into to an open session and had the discussion about that. You didn't have to go in camera.
Okay, and you brought up another interesting point. If a private citizen asks for something to be kept in camera, is that also discretionary whether we agree to that condition?
It is. Again, all of the exceptions that I highlighted for you under sub 2, and I think this would fall under one of those, and I think it's the acquisition of land, would be discretionary. So the deal, though, maybe is I'm willing to do this, but I don't want my name disclosed, and I don't want everything to be out there. So the municipality then has to figure out, okay, if we don't go in camera, then this person may not ultimately give us the land, may not donate the land, may not want people to know that he or she is doing this, and that might take away from the ability of the donation to come to the municipality. So that has to be weighed.
Okay, but as I say, I want to make it really clear. I wasn't putting you on the spot on the integrity commissioner thing. Okay. That's all well known. If you speak out of in camera, you're breaching an in camera rule. The problem I have is the fact that when I read through all this material, if it doesn't affect the price and it makes the business of the municipality move forward, it seems to be, it should have been in public. That's all. Councillor Innes.
Just to follow up, because Councillor Parrish raised some good points. If you're dealing with a property owner during an acquisition of some type, and they want to remain anonymous, or they want the conditions to remain anonymous, or they want it to not be disclosed to the public until a certain point of time of which they're comfortable with in the negotiations. As council, are we required to abide by that?
Through you, Madam Chair, to Councillor Innes, no, you're not. However, that may be part of the deal that the person is putting to you. So if they say, look, I don't want this known until X, council can say, that's the arrangement. And if we don't accede to that and we don't discuss it in camera, because that's the only way we might be able to move this further along, then this person may just not give us the land. So that's the difficulty. That's the tension in this.
And what in regards to the conditions? Let's say if there are conditions of the deal, the cost, whatever else there might be, are those FOIable in the future once it's been completed and made public, or are those required to remain confidential in perpetuity?
Yeah, Councillor Innes, Madam Chair, I'm sorry, I didn't hear the very last end. I heard you say, "Are those required to be in perpetuity?" I just missed the part before that.
I'm just wondering if those conditions are FOIable and or are maybe kept in confidence in perpetuity if requested by the landowner, as an example.
Yeah. Through you, Madam Chair, they could be kept in perpetuity, closed. Through an FOI, you would have to go through the test under that, and it may be that that information would not necessarily be something that is protected. It may be something that could be released, but that's a separate test under there. I think what's being asked is, or what may be put in place is the proponent coming forward may say, this is the deal, this is how it has to work, and if you can't guarantee me this, then I really have a problem doing this. And so council would have to make a determination as to what it is that they could live with, what then is discussed in camera, and then what is not future to be disclosed in the future. I mean, many times people will say, I'm not going to meet with you, municipality, unless you enter into a non-disclosure agreement. If the municipality wants to go through and do the arrangement, that's maybe one of the evils that you have to do. And then you have this other thing that stands in the way, the non-disclosure agreement. So you enter into that, and someone may be very well able to pierce that through an FOI request or not. And again, depending on what the circumstances are, I can't tell you, sure, they'll always get that information, or no, that'll always be protected.
Okay, and then just one more follow-up question. When an issue has been dealt with in camera and the matter has been resolved, even though there may be solicitor-client privilege information on both sides as part of the in-camera discussion, is the municipality able to make all of that information public once the issue has been dealt with and finalized?
Yes, through
Even
you,
though
Madam
it's
Chair.
solicitor-client information.
Yes, through you, Madam Chair. Solicitor-client information privilege is actually it's owned by the municipality, by the council. And I often say the council can waive that if council says, we had advice from our lawyers, and it was at the time we needed it to be confidential, but now we can waive that privilege and we can disclose that. That's a decision that council can make to agree to disclose that information and to make arrangements known to people. Now, depending on what your arrangements were, though, and whether you have overriding contractual agreements, that's a whole other question, right? For instance, one of the principles is that a municipality can't fetter its discretion through contract. So many people have misinterpreted that. They say, hold on, municipality can go and change the bylaw at any time. And I'm there, it can, but if you entered into an agreement with someone that they would build something, then there may be a problem. You may have a contractual problem, not a legal legislative problem. You can maybe go and repeal the bylaw, but that may cost you a lot in damages because you're reneging effectively on whatever contract. So that may be the same thing here, where you might have a non-disclosure, and there may be consequences from a contractual perspective.
Okay, and what if the matter, is there a timeline on expiration of matters that may not be resolved? So say you don't have a non-disclosure agreement, there isn't an overriding contractual agreement. The matter is, 5 years old or 10 years old. Can council then go back and open up that information and make it public, even though there was no resolution to that matter?
I think so. I think council can agree to do that. I'll put it another way. I'm often asked this question. There is a council that made a decision. It was in camera. Let's just say it was this. There was some sort of arrangement made to pay out someone to leave. Okay. New council comes on board, and all of a sudden, a new council member who wasn't part of that earlier council says, I want to know what happened. I want to get at those records. I think the clerk is justified to say, no, those records are confidential. They were confidential to the council at that time, and they're not available now for you to look at. I think that's appropriate. I also think it's appropriate for the member to go to the current council and say, I'd like to see this because there may be something in there. And if the quorum of council agrees, then they could reopen that and then make that record available. But if there isn't something pending before council, just because you're a member of council doesn't mean that you can get at certain records. And I've often said those records are confidential to the council at the time. I hope that gives you, I know I gave you another example, but that's the best way I can answer your question.
Okay,
Thank
well,
you.
thank you very much. Councillor Sinclair.
Yeah, looking for a little more clarification. A situation where a matter has been out in the public, newspaper articles, council resolutions, conversations, and so on, both at regional level and town level. And then there's a matter goes in camera. At what point, how are you bound, even though as a counselor, and that would be me, having information, background information that I obtained outside of anything to do with the town? So am I bound to silence on specific details that were unique to the in-camera discussion, or suddenly I'm muzzled on everything? And this is a big issue for credibility among the community, where suddenly you have to shut up. Well, people don't understand. There you go.
Yeah, through you, Madam Chair, to Councillor Sinclair. If the information is provided to you in camera and it's not publicly known, then clearly if you go and disclose it, that's a problem. But if it's publicly known, I don't think that that's a problem if it's known. But if you did receive the information in camera and that's the only way you could have received it, then you can't disclose that. But if it's known elsewhere, then it's public information. I'm trying to think of a situation, and I don't want you to give me your situation because that's a true life one. But I'm thinking of something that. It's supposed to be confidential, but yet whoever brought it forward has gone and disclosed to the media. I'm the person who brought this forward. These are the reasons why I'm doing it. Well, it's no longer confidential. It may have been provided to you at the time. It's confidential because you heard it in camera, but that part of it is now been publicly disclosed.
Okay, thank you.
Well, thank you very much. Councillor Fortini? Pat?
Yeah, thank you. Thank you, Mr. Chair. And thank you, John, for all the information. I got two questions. When something becomes public on an email and it circulates all over, do we, and it's gone all over the media, do we have to go in camera to discuss this, or it has to be in the open?
Through you, Madam Chair, to Councillor Fortini. No, if it's been out in the open, Well, it all depends on why you're going in camera to discuss it. If the person, you know about something, but then the person says they're going to sue you and sue the municipality, and the municipality wants to talk about what it's going to do. That's to me, that's an in-camera item. The fact that the person may have disclosed that they're going to sue the municipality is one thing. That gives you the opportunity to use the litigation exception, but then you can't go and disclose the deliberations of what council talked about in camera.
Yeah, I understand what you're saying. So I'm just so we get a bunch of emails, and anonymous emails. They come out and they say everything about us councillors. That should be discussed, and someone brings it forward. That should be discussed out in the open. It should not be discussed in camera, because we don't have anyone suing or anything. It shouldn't have to go in camera.
Yes, Madam Chair, through you. Yes, if it's out in the open and in public, then I think you're fully okay to go and discuss it. I don't know what the matter is, but if it's full knowledge, there may be though issues there. There may be personal matters of an identifiable individual. For instance, that the person is a vexatious litigant or a querulent. Querulent, by the way, is someone who continues to complain even though they have had multiple answers to the same question. I just found that out. I'd like to try it out on anyone. So something like that, you may want to go into camera to discuss what you're going to do about it. But if there's no in-camera exception that applies, then there is no reason for you to go in a closed session.
Yeah. Okay. My other question: anything in camera is the freedom of information. Can they get the information if someone requests it, or it's enclosed and it stays enclosed?
In general, it should stay enclosed. But however, what MFIPA has in section 6 sub 1, it says if the information discloses the deliberations of what council did, it won't be disclosed. So there is still the possibility council did everything that they wanted and tried to shelter the information and protect it. Someone may still be able to get at it through MFIPA, but they'd have to pass through a couple of hurdles, and they'd have to show that the disclosure won't actually indicate what council decided or how they arrived at that decision.
Okay, great. Thank you so much, and thank you for coming today.
Thank you.
Yes, I think we're done. Two things, John. You've done a terrific job. Even though a lot of us knew a lot of these things, walking us through it and then answering the questions has been extremely helpful. The second thing I want to mention is, speaking for the City of Mississauga and the Region of Peel, you've confirmed or reconfirmed that we have good staff and they're keeping us on our toes and our rules are in place that should be. So that is a benefit to all of us as well. So I really thank you very much for coming today. It's been very enjoyable, a little theoretical, but I groove on that stuff. I don't mind it at all. And I look forward to seeing you on TV doing more commentary. What's going on down in Toronto is most fascinating to me.
It is. I want to say thank you very much, Madam Chair, and thank you very much to members of committee. I don't know if you've discerned this, but I am kind of passionate about the area of law that I practice in, and it was very, very enjoyable for me to do this. Thank you so much for having me.
Thank you very much, and I'm sure we'll get a refresher course sometime soon, and we'll have you back.
Thank you.
Thank you.